Name is Rachita Mathur, currently working as a legal intern at LEXIS and Company. So today I am going to present a very recent case related to sedition. Every journalist is entitled to protection under Kedarnath Singh judgment. Supreme Court further quashed sedition case against journalist Mr. Vinod Dua for his YouTube video related to COVID lockdown. Supreme Court further quashed an FIR that was being registered by Himachal Pradesh Police against senior journalist Mr. Vinod Dua last year for his comment critical on government handling COVID-19 lockdown on his YouTube channel. Every journalist will be entitled to protection under Kedarnath Singh judgment on sedition set by a bench which was being headed by Justice Lalit and Justice Vineet Saran. Every journalist will be entitled to protection in terms of Kedarnath Singh judgment as every prosecution under Section 124A and Section 505 of Indian Penal Code 1860. It must be in strict conformity with scope and ambit of said section as explained in and completely in time with the law that was being laid down in Kedarnath Singh case. The court ordered that this order was given on 6th October last year. The court further rejected a prayer by Mr. Dua to direct that no FIR should be registered against any media personnel with 10 years of experience unless cleared by an expert committee. BJP leader Mr. Ajay Sharma, who filed a criminal complaint against Mr. Dua accusing him of instigating violence against government by allegedly spreading fake news. The bench further declined the accusation against Mr. Dua by Mr. Ajay Sharma. On June 2020, Supreme Court further issued an interim directions to protect Mr. Dua from arrest in matter. Although Mr. Ajay charged an FIR against Mr. Dua with grave offences under Indian Penal Code including sedition sections 2 of 124A, 268, 501 and section 505. Mr. Dua further submitted a petition before Supreme Court that the video in question shall be critically analyze the failure of Government of India regarding declaration of national lockdown and the manner in which the same was implemented. The petitioner further make a reference to politicization of army attack in response to Pulwama attack and usage of same in last elections. Additional Solicitor General appearing for government authorities further submitted that even if one cognizance of offence is made out, FIR can't be quashed. He further added that the offences given under Section 153 and Section 188 of Indian Penal Code 1860, among other offences, are clearly made out in FIR against Mr. Vinod Dua. Senior advocate who is representing the complainant, a question was arise that whether Mr. Dua, being a journalist, is entitled to protective measures of preliminary inquiry. Senior advocate further argued that it is not that a journalist is bereft of a preliminary inquiry, but will be left with discretion of investigating agencies. Court held that Dua has no intent to incite people or to show any tendency to create disorder or disturbance of public peace by resort to violence, which is an essential element in case of sedition given under Section 124A of Indian Penal Code 1860. Further, the court states that both sedition and public mischief can't be made out against Mr. Dua. the court further conclude that all the offences that was being registered against Mr. Dua was unjust, and hence it is violative of rights of petitioner that has been granted under Article 19 subclause 1 of clause A of Constitution of India. Thank you.